All right, welcome to the next episode of Legally Norette, Legally Raven here, where we're going to finish reading this chapter. The effect of actual notice on the defendant. Suppose the service of process does not actually reach the defendant, but she learns in some other manner that the action has been filed. This might happen, for example, if the plaintiff lawyers a courtesy copy of the complaint to defendant's counsel, or if a third party learns of the suit and tells the defendant or her lawyer. May the defendant object based on lack of service by the book. Most courts do not view a judgment as valid, even if the defendant actually received notice of the action, unless service is made in compliance with the applicable service rules and statutes. Courts view proper service or process delivery of papers by a method authorized by statute or rule, and that is constitutionally proper as necessary to acquire personal jurisdiction over a defendant. The federal rules clearly contemplate that a defendant may object to service even though she actually learns that she has been sued. Rule 12B, 4, and 5 authorize defendants to move to dismiss an action based on improper service of process or insufficiency of the process, the summons. To make the motion, the defendant would, of course, have to know that the case had been filed. The principle seems unduly fastidious. The purpose of proper service, after all, is to inform the defendant that he has been sued. If it is clear that the defendant has received notice, should that suffice? Virginia has an interesting statute, Virginia Code 888, 2005, except for process commencing actions for divorce or annulment of marriage or other actions wherein service of process is specifically prescribed by statute. Process which has reached the person to whom it is directed within the time prescribed by law, if any, shall be sufficient, although not served or acceptable as provided in the chapter. Shouldn't every state or the federal rules have a statute like this? Validating service as long as the defendant receives actual notice. Note that this does not relax standards for service in divorce cases. Perhaps not. The statute might create more problems than it solves. If there is not clear rules on how service is properly made and when it has been completed, there's likely to be difficult disputes about what the defendant knew and when. I agree. You got to know everything you're saying, particularly if the date of service is crucial to meet the applicable statute of limitations. These requirements should be clearly spelled out and consistently applied, and if ignoring the rules carries no penalties as long as actual notice is received, there is much less incentive to follow them in the future, even though they often reflect the legislature's judgments about what service is best. Proper service but no notice. Suppose that Jarbo serves process on Fuentes by a means that is authorized by statute and constitutionally sufficient, but Fuentes still does not find out about the suit. Perhaps Jarbo mails the summons and complaint to Fuentes at Fuentes' home address, a method authorized by local statutes and using constitutionally sufficient under Mullane, but for one reason or another, the defendant does not get the papers. Perhaps one of Fuentes' kids brings in the mails but throws out the court papers with the recycling, or the kid puts the envelope on a cabinet and the envelope falls behind it. Service was properly made here, but Fuentes still did not know that he had been sued. When Fuentes finds out about the default judgment, he will doubtless move for relief from judgment under Federal Rules of Civil Procedure 60B. Jarbo has a credible argument that the judgment should stand because he complied with the rules of service and the method was acceptable under the due process standards, but the defendant still did not learn about the case and did not have a chance to defend it. A practical judge is always going to grant relief. A practical judge is always going to grant relief from the judgment in the situation, even though service is done by the book. Few judges are willing to see the defendant lose the chance to defend the lawsuit when she never knew it had been filed. The restatement, second judgment, section 65, judgment rendered without adequate notice may be avoided. Consequently, the plaintiff has as much interest as the defendant in ensuring that both complies with the service statute or rules and actually informs the defendant of the action. The plaintiff will rarely win a case if the defendant defaults for lack of notice. More likely, the defendant will later learn of the action and move to set aside the entry of default or default judgment, and the motion will be granted. Consequently, the failure to achieve actual notice will more likely lead to a delay than an enforceable judgment for the plaintiff. Service of later filings and civil actions. Service of later This chapter has focused on service of the original complaint and summons because initial service and process serves the crucial function of giving notice that the action has been filed. All subsequent papers filed in the action must also be served on all parties in the action, including later proceedings, motions, trials, memoranda, and many other documents. Later documents may be served on the other lawyers rather than the parties under Rule 5. And under Rule 5 may be served by first class mail. All federal courts now accept electronic service and filing of court papers after the initial complaint. See WWS Court. Okay, let's look at this. Okay, the link no longer works. The book is old. Okay, for an example, the local rules implementing electronic, or an example of local rules implementing electronic filing. See United States District Court for the Eastern District of Texas, Local Rule CV5, which mandates electronic filing of court documents in most cases. In the Eastern District of Texas, as another jurisdiction with rules of this type, all attorneys admitted to practice before the court must register with the clerk, and users of the court's electronic filing system and receive a user login and password that allows them to access the course case management electronic case file system. Under CV7, all motions, responses, replies, and proposed orders, if filed electronically, must be submitted in searchable and editable portable document format. All other documents should be submitted as a searchable PDF whenever possible. Local Rule CV5 provides that receipt by the filing party of a notice of electronic filing sent automatically by email from the court is proof of service of the document on all counsel who have consented to electronic service by registering for the CM-ECF system with the clerk. The Committee on Rules of Practice and Procedure of the Judicial Congress of the United States has proposed amendments to Federal Rules of Civil Procedure 5 that would make electronic filing of papers after the complaint mandatory in most cases in the federal court. Electronic filing has matured. Most districts have adopted local rules that require electronic filing and allow reasonable exceptions as required by the formal rule. The time has come to seize the advantages of electronic filing by making it generally mandatory in all districts for a person represented by an attorney. Preliminary draft of proposed amendments to the federal rules of appellate procedure, bankruptcy, civil, criminal rules is right here on this link. The proposed revision will make electronic filing of papers after the complaint mandatory for represented parties unless non-electronic filing is allowed by court. Non-electronic filing is allowed by court rule or local rule. Proposed amendments to Rule 5D3A. U.S. courts, okay, amendments published comment. Pro se litigants would be authorized to what could be authorized to file electronically or required to do so by court order or local rule. For papers filed electronically, a notice of electronic filing from the court was served as the certificate of service for the paper. Proposed Rule 5D1B. U.S. courts. Federal Rule 45 and similar state rules include separate provisions for service of subpoena. A subpoena is a court order to a person who is not a party to the litigation to appear, to give testimony, or produce documents. Subpoenas must be served by delivering a copy to the named person. Federal Rules of Civil Procedure 45B1 would suggest personal in-hand delivery service. However, not all courts read this phrase to require in-hand service. See Hall v. Sullivan, 229 FDR 501, approving service by Federal Express. The relation of service process to personal jurisdiction. As noted above, a court cannot acquire personal jurisdiction over defendants without proper service of process. However, it does not follow that if the defendant is properly served, the court will have personal jurisdiction over her. Service and personal jurisdiction are separate, though related principles. Personal jurisdiction requires that the defendant have an appropriate relationship to the state and makes it fair to require her to defend there. Service of process fulfills separate due process requirements, providing notice of the suit to the defendant so she can appear and defend. Consider the following questions to help clarify the distinction. Danziger, who lives in Georgia, sues Alioto from Florida for injuries in a car in an auto accident they had in Florida. Danziger files a suit in Georgia federal court. Alioto has no contacts with Georgia. Danziger's counsel arranges for service of process on Alioto in Florida. A Florida process service goes to Alioto's machine shop. Then Florida and hands her the summons and complaint in action. A service of process on Alioto proper does the have personal jurisdiction. Yes, service is proper, but they don't have jurisdiction. Which allows service on defended by personal delivery. It does not specify that personal delivery must be at any particular place, so handing the papers to Alita at the shop is proper service. However, the Georgia court lacks any basis to exercise personal jurisdiction over Alioto. The accident took place in Florida, and the example indicates that Alioto has no other contacts that might support personal jurisdiction over her in Georgia. Then verifies a suit for her injuries in the accident in a Florida federal court. He serves process by publishing notice of action in the newspaper in the county where the action is pending for 3 weeks in a row. Is service of process on Alioto proper does the court personal jurisdiction do so? That is the way to do service, but I think you have to exhaust all the other possibilities first. Here, the Florida court could exercise personal jurisdiction over Alioto because the suit arises about her contact with Florida driving in the state. However, publication was almost certainly insufficient means of notifying Alioto of the suit. Even if a Florida statute authorized service by publication, Mullane suggests that publication notice is only proper if nothing better can be done to provide actual notice to the defendant. Presumably, Danziger and Alioto exchanged papers after the accident, so Danziger's attorney has an address for Alioto. He could attempt service by mail if authorized by Florida statutes, or he could serve under Federal Rules of Civil Procedure 4E2A or B at Alioto's home. Danziger files a lawsuit for his injuries in the accident in a Georgia federal court. He serves process on Alioto by having the process service deliver the summons and plate to Alioto at her hotel while Alioto is visiting Atlanta. Is service of process on Alioto proper? Does the court have personal jurisdiction? Georgia federal court, because it is, yeah. Service is proper under Rule 4E2. Enhanced service is good as it gives them the providing action of Sky, and there is probably personal jurisdiction available based on enhanced service within the state, but is over $75,000. In Burner v. Superior Court, Supreme Court upheld jurisdiction based on enhanced service within the farm state. The court did not hold that this would always suffice to support jurisdiction, but it frequently will within the farm state. Okay, I'm sorry. Yes, because she's in the farm state. The point is that you must always analyze these two due process requirements separately. Both must be satisfied, and satisfying what is not satisfied. Why is this in federal court? This isn't a federal court issue. She got served within the state. Like Burnham is the divorce case, 1990. Okay, I need to make sure this again because this doesn't make sense to me. It seems like the court shouldn't necessarily have personal jurisdiction because the amount of controversy, and this isn't a federal question. The point is that you must always analyze the two due process requirements separately. Both must be satisfied, and satisfy one does not satisfy the other. But didn't Pennoyer say Pennoyer say courts couldn't do this? Didn't the Supreme Court say in Pennoyer v. Neff that process from the tribunals of one state cannot run into another state? The summoned parties their domicile to leave its territory and respond to proceedings against them. 95 U.S. 777. How can a court in one state serve process on a defendant in another state and require that defendant to come into the forum state and defend a lawsuit without contradicting the statement? Yes, Pennoyer did say that, but the statement in Pennoyer is no longer true. After international issue, an Oregon court can require a defendant from California to come into Oregon to defend a claim that arises out of the defendant's minimum context in Oregon. An adequate notice can be given even if it is delivered to the defendant in another state. Handing the summons and complaint to the defendant is an excellent way of telling her that she has been sued, whether you do it in Oregon or California. After international issue, Oregon can require a defendant from California to come to Oregon and defend the claim that arises out of the defendant's minimum context with Oregon. An adequate notice can be given even if it is delivered to the defendant in another state. Handing the summons and complaint to the defendant is an excellent way of telling her she's been sued, whether you do it in Oregon or California. If Penoyer sued Neff today in an Oregon court for breach of conduct, Neff made with him in if Penoyer sued Neff today in an Oregon court for breach of contract, Neff made with him in Oregon, the court will have personal jurisdiction over Neff because hiring Mitchell in Oregon is a minimum contact that gave rise to the claim. And under Mullane, mailing the summons and complaint to Neff in California, if authorized by Oregon Service of Process rules, would be a constitutionally proper means of letting Neff know about the case. Didn't Penoyer say courts can do this? The point is that didn't the Supreme Court say in Penoyer v. Neff that the process from the tribunals of one state cannot run into another state and summon parties that they are domiciled to leave its territory and respond to proceedings against them? Okay, so Oregon can't tell somebody in California to come back to Oregon for this case, but that changed. Notice 6. Notice and service summary of basic principles. Due process of law requires, among other things, that a defendant be properly notified that an action has been commenced against her so that she can appear and defend the action. The method of providing such notice is referred to as service of process. In Mullane v. Central Hanover Bank and Trust, the Supreme Court held that notice must be given by a means reasonably calculated under the circumstances to apprise interested individuals of the pendency of the action and afford them an opportunity to present their objections. Generally, publication alone is not sufficient under Mullane unless nothing better can be done. Usually something more than publication can be done. Personal delivery and mail service are generally upheld, though mail might be insufficient in some circumstances. Every court system has a detailed set of procedures set forth in court rules or statutes governing service of process. In addition to being constitutionally sufficient, service must comply with the statutes or rules applicable in the court in which the case is filed. A court does not have proper jurisdiction over defendant just because process has been properly served, and service may be improper even if there is a valid basis for exercising personal jurisdiction over the defendant. Each requires separate analysis. The term service of process is often used to refer to the delivery of litigation papers or orders other than the summons and complaint to the defendant. Often court rules or statutes specify other, less elaborate means of service, serving these later papers in the action. Every course of these is service. Okay, and that is the end of chapter 10 on, I went too far. Service, notice, and process, I believe what this is all about. So anyway, so thank you for tuning into this episode of Legally Marette, Legally Raven.